Hello everyone, this is Koyel Sinha. I am student of 5th year, Surendranath Law College, Calcutta University. Today, my session will be on Indian Contract Act, and I hope this session will be helpful and informative who are watching it. So, Indian Contract Act, the term contract, which has been defined under section 2H of this act, and simply the contract means the expressed document or written document binding upon two persons to provide service or product. This act, which came into force 1st September 1872, so it considers one of the oldest acts in India, and this act mainly based on English common law consisting of judicial precedents. The act is divisible into two parts. The first part is section 1 to section 75, which deals with common law or common principles of contracts, and this principle applicable all on various kind of contract. And the second types of contract and the second part section 124 to section 238, it deals upon five kinds of special contract, and there are 5 kinds of special contract: contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and contract of agency. So there are 5 kinds of special contracts, and the middle part of this act, that means section 76 to section 123, it deals upon Sales of Goods Act 1930. So we will discuss this session, or we will discuss in this session on the various principles or common basic principles of this act. Here we will discuss about the types of contract. It may be classified from the following point of view. On the basis of enforcement, there are 5 kinds of contract: valid contract, voidable contract, void contract, unenforceable contract, illegal and unlawful contract. First is valid contract. Section 2H of this act defines that an agreement which fulfills all the conditions mentioned under section 10 of this act is a valid contract. Second, the voidable contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other, is voidable contract. Third, void contract. The contract which is not enforceable by law is void contract. In this case, contract is valid when is made, but subsequently it becomes void due to certain circumstances. You can see this kind of contracts in section 56 of this act. The fourth one is unenforceable contract. The contract which is unenforceable because of some technical defects, likewise absence of writing, registration, time barred by law of limitation, etc. One or both of the parties cannot sue on it. The fifth one is illegal or unlawful contract. Section 23 describes some conditions when an agreement may be unlawful or illegal. These may be agreements whose object or consideration is forbidden by law, or of such a nature that if permitted it would be defeat by provision of law or fraudulent, etc. That means all illegal agreements or contracts are void, but all void agreements are not illegal. The third classification is based on the basis of extent of execution, and in this basis we can classify the contract into 4 parts: executed contract, executory contract, unilateral contract, and bilateral contract. Executed contract, where the both parties have performed their obligations in this agreement, it's known as executed contract, जहाँ पे एक बुक सेलर ऑन कैश पेमेंट बुक सेल करता है to the buyer. Secondly, executory contract is a contract in which one or both parties are still to perform their obligations. Such are future contract. And third is unilateral contract, where one party has performed his part at the time of formation and obligation is outstanding only against the other. And the fourth is bilateral contract, where both parties are outstanding at the time of formation of the contract. So we have classified and have learnt about the types of contract on the basis of performance, on the basis of creation, on the basis of execution. Now I will discuss about the very important concept of contract, that is essentials of contract. All such agreement are contract if they satisfy the conditions mentioned in section 10 of this act. Section 10 provides all agreements are contract if they are made by the free consent of parties competent or to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So here are some elements to become a valid contract. And as you can see, the following are the essential of valid contract. First is agreement between two parties. So there must be always two parties to create or constitute a contract. Secondly, lawful consideration and lawful object. Contract में lawful consideration and lawful होना, object होना, it is very important. And third is parties competent to contract. That means the party who are constituting contract or making contract, they have to competent in age and they should be in sound mind when they are creating or constituting a contract. Fourth is free consent of parties. Section 14 of this act defines free consent. It provides that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation and mistake. जहाँ पे कोई कॉन्ट्रैक्ट बन जाता है और वो अगर कंसेंट ये 5 एलिमेंट के द्वारा नहीं होता है तो वो फ्री कंसेंट माना जाता है और उसके द्वारा कॉन्ट्रैक्ट वैलिड माना जाता है. And the fifth one is lawful object. So these are the five elements of a valid contract. Next, we will know about another very important topic, that is offer is different from the invitation to receive offer. An offer is the final expression of willingness by the offerer to be bound by his offer. Sometimes a person does not make an offer but invite others to make an offers. The landmark judgment Pharmaceutical Society Britain versus Boots Cash Chemist 1953. In this case, the court held that a shopkeeper catalog price is not an offer. It is only an invitation to intending customers to offer the buyer at the indicating price. Similarly, display of goods in a shop with price sheets attached is not an offer. It is only the offer to buy, and there is always no sale effected till the buyer's offer was accepted by the acceptance of price. So, the invitation to receive an offer is not offer. It's just indicating the person that he may constitute an offer to that person. So, these two concepts are different from each other. Next, we will know about the revocation of proposal and acceptance. जैसे करके इसका कंस्टिट्यूशन होता है, बस थोड़ा और कंडीशन इस पे अप्लाई होने से ये रिवोकेशन भी हो जाता है, रिवोक भी हो जाता है. सो रिवोकेशन ऑफ प्रपोजल एंड एक्सेप्टेंस. Section 6 of this act lays down the circumstances when an offer lapses. According to this, a proposal is revoked by the communication of notice of revocation by the proposer to the other party. The next one is by the lapse of time prescribed in such proposal for its acceptance. And the third condition is by the failure of the acceptor to fulfill a condition precedent to acceptor. And the fourth is by the death or insanity of the proposer. So there are 4 conditions on which a proposal may be revoked at any time. Similarly, there is revocation of acceptance. There are some provisions of this Act on which acceptance also can be revoked. Section 5 of the Indian Contract Act provides that an acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterward. इसका मतलब है एक्सेप्टेंस किसी भी टाइम में रिवोक हो सकता है, लेकिन वो एक्सेप्टेंस अगर कंप्लीट हो जाता है तो वो रिवोक नहीं होगा. So in this process you have learned basic concept about the contract, Indian Contract Act 1872. So it was my try to teach you some basic concept of this act. Thank you and namaskar.